Good morning, Colorado. This is the Colorado Oil and Gas Conservation Commission. We are going live on November 23rd, and we will be taking up the mission change rulemaking today. With that, we have 109 participants and counting. Appreciate everyone being involved. We will look to Hearings Manager Thomas for a roll call.
Certainly. Commissioner Hackett.
Here.
Commissioner Gonzalez.
Here.
Commissioner Mock.
Here.
Commissioner McGowan.
Here.
Commissioner Messner.
Here.
Commissioner Nanjapa.
Here.
And Chair Gibbs. Chair Robbins, excuse me.
Not a problem. Thank you. Here.
You have 7 out of 7 commissioners present.
All right. Thank you very much. With that, we will move into discussion on our rulemaking series that we've debated vigorously over the course of the last several months. I think we're going to start with the 1200 series, and would look to Director Murphy perhaps for a summation of where we're at with regard to 1200.
Thank you, Chair, and good morning, Commissioners. Good morning, Colorado. We provided 2 commissioners around, I think, between 5 or 6 o'clock and parties. Sorry. We provided commissioners, parties, and on the website revised 1200 series rules based on the outcome of Friday's conversations with the commissioners and direction. I believe that red line reflects the changes that you requested of us as a group. We took about another 24 hours to finalize a statement of basis and purpose that was also shared with commissioners, parties, and posted to the website Saturday. We have gotten a few comments from commissioners over the last 24 hours that would be kind of the final changes to the statement of basis and purpose. And so I think that perhaps the best course of action would be to ask one of our AAGs to walk through maybe some of the substantive SBP comments that the world would not have had the benefit of seeing if they reviewed the statement of basis and purpose shared on Saturday. Make sure all the other commissioners are aware of their co-commissioner comments, and then put it to you to see if there are remaining issues in the 1200 series that need to be addressed before we kind of move into what I hope is a broader vote on the 8, 9, and 1200 series votes at some point this morning. So,
very good. Thank you, Director Murphy. AAG Stafford, I'm not sure if you're the right AAG, but I'm going to call on you first if you'd like to walk us through.
Sure, I'd be happy to. I would just like to say that there were, as Director Murphy referenced over the weekend, we did make some typographical changes as well as some other non-substantive edits to more accurately reflect some of the commissioner discussions on Friday. But I would like to share my screen if that is okay. And I have highlighted 2 areas where there were edits made most recently.
Great. Please share your screen.
And I will enlarge that just to make sure everybody can see it. Over the weekend, we received a comment from, I believe it was Commissioner Messner, to clarify some of the discussion around the setbacks that were referenced in Rule 309. We believe that these 3 sentences here will provide some more information around the conditions of approval that CPW may offer as a result of consultation.
Great. Is there any, are we doing this edit by edit, or do you want to present any and all proposed changes, Ms. Stafford?
Sure, I can. There was this one that was substantive, and then we had another substantive edit just a few pages down. As I mentioned, there were some other edits made, but they were really clarifications and sort of finding typographical and grammatical errors and things like that. So there was an addition here in the discussion of the greater sage grouse and Gunnison sage grouse section. This is on page 19. And this change was made just to more accurately reflect commission deliberations on Friday.
Okay, with those substantive edits announced to the record, do commissioners have any thoughts, questions, comments, concerns relative to those two changes? Okay, seeing none, do commissioners have any other proposed thoughts, questions, comments, edits to either the 1200 series SBP or the 1200 series rules as presented to us? Commissioner McGowan.
This isn't a gotcha, promise. After we talk about all the series and our work today, I wonder if we could talk a little bit with staff about how guidance gets drafted for folks who are listening to the Zoom call, and these work groups that are going to get set up, and potential roles for the commissioners. I would be interested in participating in some of these things, and I think it would be maybe a good discussion at the end of all this. A lot of this came up for me in this series because we talked a lot about working groups and guidance and clarifications, and so but I think there's stuff in the other series as well. So I just was hoping that maybe we could talk a little bit about that at the end of all of this.
Yeah, thank you, Commissioner. Director Murphy.
Thank you. Commissioner McGowan, I think that is a wonderful request, and I'm so excited to hear it. I am absolutely unprepared to talk about that in any semblance of an organized fashion today. But we have started kind of an internal tracking document on this to make sure we know where we're going and we're doing what we said we would. Is there a chance that we could present that to all of you maybe next week during a public hearing and have exactly that discussion?
Yeah, and that's kind of where I was going, is there are quite a few areas in which we'll be doing work on guidance as well as work on task forces and other things. And so I think once we get past enactment of rules and regulations, divvying that up amongst commissioners and amongst staff and figuring all that out really does make sense. And for the world at large, we have caught the Colorado Natural Heritage Program edit. Thank you to several of you who have caught that, and that typographical error is now corrected on the statement of basis and purpose. So to all of you who caught that, you get cardboard cookies. Thank you. Other suggested thoughts, questions, comments, concerns, final ideas about the 1200 series? Commissioner Nanjapa.
I don't have any edits, but I just wanted to thank the staff because there were a lot of little nuances and kind of different situational considerations to put in. And that's what I was really looking for in the SBP. And I really appreciate the attention to detail. I think it was really thorough. So thank you.
I agree, 100%. That 100% hashtag that we can do on text. That's what I just said. Okay, our order of business is going to be that we are going to address any final comments, edits, questions, comments, concerns, etc. on 1200. Then we're going to go to 800, and then we're going to go to 900, and then we're going to take a final vote on 8, 9, and 12. So last call on 12 at this point. Otherwise, I'm going to move us over to 8. We've got some conforming edits that we need to tackle there.
Chair, if I may.
Yeah, Commissioner or AG Stafford.
Yes, thank you. I do have a couple of edits I wanted to present the commission with on the rules. We found a few places where the word approved was used twice. in relation to the BMPs, the listing of the BMPs. So we wanted to present that to you and make a suggestion about how to remedy that. So as you'll see here, I'll make it even bigger. I believe this is 309E5D. It's in 1 here, 1cc, or little I-cc. We have approved Form 2A approved, which is, as I said, a bit redundant. And this occurs a couple of times just in the listing of the appropriate BMPs. So we would suggest that the second approved be removed from each of these areas.
Very good.
Okay, so it appears there, and I will delete that as you watched me do it. Right there, and it also appears in 1202A10. And then I did want to bring up one more thing. We, during deliberations on Friday, I think, or excuse me, when staff last presented, we raised an issue related to 1202A8, changing the will here to may. And I'm not sure that there was a decision that was made on that. So I wanted to flag that for everyone.
And I think the discussion there was the concept of will to may.
Okay.
So I think that that would be an appropriate edit.
Okay. And then with that, the 1200 rules should be final.
Commissioner Messner?
Thank you, Mr. Chair, and thank you all for the work that was done on this in order to capture what was a diverse set of instructions, to say the least, I think. And so I think certainly that that work over the weekend captured a lot of information in a way that was able to be read and it was clear. But for the sake of clarity, I just want to confirm again on the record that that modification in the statement of basis and purpose that I suggested had to do primarily with the 300 to 500 foot buffer for aquatic habitats, for the specific aquatic habitats, and the fact that those 411 BMPs were not the only BMPs that may be necessary or reasonable to impose in order to be protective should the waiver be considered and granted, to be able to locate in those areas. And so I wanted to make sure, just confirm once again that that modification in the statement of basis and purpose does allow for additional BMPs to be placed on any suggested location within that 300 to 500 foot buffer over and beyond the 411 BMPs that are in the rules. Is that correct?
AAG Stafford?
Yes, thank you, Chair Robbins. Yes, Commissioner Messner, that edit is intended to capture what you relayed to us about the BMPs within the 300 to 500 foot buffer.
Okay, thank you very much.
Any other final thoughts, comments, questions on 1200? All right, seeing none, we're going to move to the 800 series. And in that regard, I understand that there is potentially the need to reopen the record so that we can allow our AAGs to provide some substantive edits relevant to EPA and their certification of the UIC program. With that, I would turn to AAG Davenport for an introduction and then perhaps AAG Minor for the substance.
Thank you, Mr. Chair. That's correct. Commissioners, I think as you are aware, the EPA by law is required to certify our UIC program. Subsequent to your preliminary final vote on the 800 series, there was a conversation with EPA where EPA required some edits to the rules in order to certify our program. As you may recall, we closed the record on 800. Our rules allow us to reopen the record. And so I recommend that we have a motion to reopen the record for the purpose of receiving staff's proposed changes to the 800 series rules. At that point, AAG Minor will explain exactly what those edits are, and the commission can discuss them, ask questions about them. Assuming that everything is acceptable to you at that point, we can then close the record on the 800 series and proceed along with further consideration of any conforming edits to the SPP or that series as well. So before we turn it over to AAG Minor, as I said, Mr. Chair, I would request that you encourage a motion to reopen the record, or to reopen the record for the 800 series to consider conforming changes to the 800 series as requested by EPA.
Very good. Do we have a motion to reopen the record in the 800 series?
So moved.
So moved.
Oh,
Second.
we've got a motion and a second. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Mr. AAG Minor, the record is now reopened for your ability to provide us some additional thoughts.
Thank you, Mr. Chair. And can everyone see my screen okay?
We can.
Great. So as AAG Davenport mentioned, staff have submitted the 800 series for a preliminary review by the EPA Region 8 staff who are in charge with approving exercises of state and tribal delegated authority under the Safe Drinking Water Act for underground injection control programs. You may recall from my presentation during the staff presentation on the 800 series that the 800 series is unique because COGCC is exercising delegated authority under the Safe Drinking Water Act from the United States EPA. And therefore, in order to be able to lawfully enforce any rules in the 800 series, there does need to be a formal delegation of authority from EPA certifying that the rules fully comply with all provisions of the Safe Drinking Water Act and its implementing regulations that apply to Class 2 underground injection control wells. So staff is incredibly grateful to their partners in EPA Region 8 who reviewed the 800 series as well as over 200 pages of supporting documentation comparing the federal regulations with the 800 series in record time, just under a month. And while EPA cannot take a formal action to approve or deny the exercise of delegation authority until the conclusion of the rulemaking, our federal partners at EPA did provide a preliminary review and identified essentially 4 changes that needed to be made in order to fully comply with federal law. So I'll just walk through these fairly quickly. The first 2 in rules 801E as well as rule 802B and 802E really are just codifying and putting regulatory text to reflect an existing practice. So you may recall from the discussion of the 800 series rules by staff and by stakeholders that in order for an aquifer exemption to become actually effective, EPA has to approve that aquifer exemption. And this is a practice that has been in place since the 1980s when EPA first delegated authority to COGCC to implement the Class 2 UIC program under the Safe Drinking Water Act. And EPA asked under its current practices that that requirement actually be codified in the COGCC rules, so explicitly reflected in the rules. So in order to reflect that, staff has codified that practice of just specifying that operators cannot inject fluids into a UIC aquifer until that aquifer is formally exempted by EPA in Rule 801E, and in Rule 802E, clarifying that at the conclusion of the state process for approval of an aquifer exemption, that aquifer exemption still has to be submitted to EPA for final approval. So again, neither of these are substantive changes, but they more accurately reflect and inform the public and the regulatory text about the relationship between COGCC and EPA and what steps have to happen on the EPA side for an aquifer exemption to be approved. The third change that you can see up there is in Rule 808A3, and this is the rule governing injection of non-produced fluids into Class 2 UIC wells. You may or may not recall the discussion that I provided and that Mr. Andrews provided about the different classifications of fluids that can be injected underground. There are 6 classifications under the Safe Drinking Water Act, and COGCC only has delegated authority over Class 2 fluids, which are roughly the same thing as E&P waste, any fluids that come back up to the surface out of an oil and gas well in the process of completing the well that are not actually oil or gas. In reviewing the rules, EPA identified that one category of non-produced fluids that was listed in Rule 808A3 that would be otherwise allowed to be injected into a Class 2 UIC well does not meet EPA's definition of a Class 2 fluid, and that's groundwater recovered during a remediation project, because some of that groundwater could potentially not be produced through an oil and gas well. It would be a fluid classified as a Class 1 fluid under EPA regulations, and therefore it could not be injected into a Class 2 well. So staff have struck that. Of course, an operator wishing to dispose of that fluid through an underground injection certainly can still do so. They would just need to do so in a Class 1 well, which in Colorado is regulated directly by EPA. So with that, I am happy to answer any questions that you might have about these 3 changes suggested by EPA.
Thank you, AAG Minor. Just, it goes without saying, but I assume that our subject matter experts, Mr. Andrews and others, et cetera, are all comfortable with these proposed changes?
Yes, that's correct. I should have said that as part of our great partnership with our federal agency partners, Mr. Andrews, Ms. Byrne, and Dr. Kaler were all there with me as we met with their counterparts with EPA Region 8, and we worked out these edits together, sort of line by line, and all parties involved have signed off on them.
Thank you so much. Do commissioners have questions relevant to these final edits as negotiated between our fine partners at EPA and COGCC staff? Okay, with that, AAG Davenport would look to you, but I assume you're going to be encouraging us to close the record.
That is correct, Mr. Chair.
I'm getting good at this after all these months and years. Do we have a motion to close the record in the 800 series?
So moved.
Second.
Okay. We have a motion and a second to close the record in the 800 series. Is there further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? All right, the record is now closed in the 800 series. And at this point, I invite commissioners for final thoughts, questions, deliberations, comments with regard to the 800 series rules as presented to us, as well as the statement of basis and purpose in the 800 series. All right, Commissioner Najapa.
Thank you, Mr. Chair. I was just curious if we were going to have either AAG Davenport or someone else walk through anything that changed from what went out in the red line as we did for the 1200 series. I think, and I'll just look to AAG Davenport. I know he and I discussed one possible thing, but it was not I was sort of, I gave him sort of a wishy-washy direction on whether or not to incorporate it. So I wasn't sure if it got incorporated.
AAG Davenport.
Thank you, Mr. Chair. I believe everything was incorporated that was discussed. Commissioner Najapa, could you reference the one wishy-washy thing that we discussed, unless you would like to go offline for a moment?
No, I think, you know what, I'm thinking it actually was more pertinent to the 900, which I think we are not quite yet discussing. So I think I was thinking of the SBP with both of those together. So I can hold my comment until we go over that, but thank you.
Okay, Mr. Chair, it's been, I've been reminded that I don't believe that we actually closed the record on 1200 series. And so I think it would be appropriate at this point to encourage a motion to close the record on 1200 series as well.
So encouraged.
So moved.
Second.
We have a motion and a second to close the record in the 1200 series. Any further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? We have formally closed the record in the 1200. AAG Davenport, did we close the record in the 900?
We closed the record in the 900 back when we were discussing the 900 series, and I don't believe it's necessary to reopen the record on 900 series at this point.
Okay, so we have no further edits, comments, questions, suggestions from staff relevant to the 900. We have before us the 900 as presented in both rules and the SBP. I think at this point, we're looking for any further questions, dialogue, et cetera, with regard to 900. AAG Minor has unmuted himself. I recognize you.
Mr. Chair, I will just note there was only one change suggested by a commissioner aside from the one that I believe Commissioner Nanjapa would like to raise that has been made to the 900 series statement of basis and purpose or rule text since the final drafts were released last Thursday, the 19th, and that is adding the missing word isotope in the discussion of Rule 909J1K, which Commissioner Gonzalez noticed was missing. So that was just a single typo that was corrected in the statement of basis and purpose. And other than that, there have been no changes since the Thursday the 19th draft.
Very good. Thank you for clarifying that. Commissioner Nanjapa, can I call on you?
Sure. Thank you, Mr. Chair. So the issue that I raised was related to subsection 912 about spills. And I think it was 912B1I talks about the gas seeps, and there is language there about, that it's not necessarily reflecting responsibility of the entity who detects it. But I had thought that our discussion and deliberation was a little bit more broad for any spill in any situation. And so I was recommending some language to that effect at the beginning of that section. Yeah, I think just the idea that, any spill that is observed in any circumstance by an operator, would need to be reported even if it wasn't their direct property or equipment. And so I know I discussed this very briefly with AAG Davenport, so I'm not sure if maybe there was a decision to whether to or to not include, or if that text is in there.
AAG Davenport, AAG Minor, I'm not sure whom to look to.
Mr. Chair, I don't have anything substantive, but perhaps I can share my screen so that all the commissioners can see the relevant part of the statement of basis and purpose.
Please do.
Mr. Chair.
Yeah, I'm sorry. I was looking at the language there, Commissioner Nanjapa, but would you like to clarify? I think I see your point, but please.
Thank you. Yeah. So this part I thought was fine, and it does get at what I was talking about, but it is specific to this particular subsection on gas seeps, and so I had thought, and I looked to my fellow commissioners as to whether or not they agree that we were our discussion was broader about any sort of spill detection scenario, you know, whether it's a transfer of ownership and some of the equipment belongs to one operator and some belongs to another, and one operator notices a leak in the equipment that isn't theirs, you know, or whatever the scenario may be. That doesn't imply that they would necessarily have to do anything, but rather just report to us so that the commission could take action as needed and determine who the owner is.
Commissioner Gonzalez?
Thank you, Mr. Chair. Yes, and I recall that being the substance of our deliberations and our communications. I was curious because we were deliberate with this paragraph. I think it was added during deliberations, if I'm not mistaken. And I'm curious if the language Rule 912B 1I requires reporting, and that we don't anticipate the assumption of responsibility to act as a deterrent to reporting, if that captures the same sentiment.
AAG Minor?
Thank you, Mr. Chair. So, Christian Gonzalez, this paragraph was added by staff in response to the commissioner's initial deliberations on the 900 series. It was not a change made as a result of the final vote on the 900 series, which I believe happened on November 5th. So that's why it's not in red line. Staff may have misunderstood the intended scope of the commission's edit. Sorry, my headphone just flipped out for a moment. So I believe that if it's the commission's intent to apply this to all forms of spills and releases that are subject to Rule 912B1, additional edits would need to be made. So perhaps I could suggest those in red line text for the commission to review now.
Please, thank you, Mr.
And I would note that this paragraph would likely need to move to the beginning of the discussion of Rule 912B1 rather than being embedded in the section discussing Rule 912B1I.
We'll all wait patiently for the magic that is AAG Minor.
And I believe that the edit I just made on the screen should be sufficient.
Commissioner Najapa?
Thank you, Mr. Chair, and thank you, AAG Minor. I think that is good. The only thing I would possibly suggest is I think we have something else earlier in the 912 section about the commission wanting to have that spill reporting as quickly as possible so that they can take action, you know, just sort of to protect, you know, to fulfill our mission of protecting public health, safety, welfare, environment, et cetera. And so maybe we could just place it adjacent to that, if that makes sense, or otherwise reiterate that point, you know, that the intent here is, again, not to, because we're trying to fault anybody, but rather to just make sure that we're protecting as per our mission.
AAG Minor?
Yes, thank you, Mr. Chair. I think we can add that language, and if you'll bear with me, I might stop sharing my screen just for a moment so that we can sort of, I can get this into the clean draft, so it's easier to see the edit and figure out the placement as Commissioner Njapa suggested. So I might take just a moment to do that, and also suggest that if possible, Hearing Officer Thomas could potentially zoom in Mr. Dronlo, because I believe he has some feedback he'd like to provide the commission about the suggested edit in the context of how Rule 912 functions, if that is acceptable.
Yes.
Chair, I would note, I'm not 100% sure Mr. Dronlo's, he's proving me wrong. I know a number of us have made vacation plans, so he's in transit at least, so we'll see.
Let's see who appears under the nickname Greg Duranolo.
Good morning, commissioners. Thank you. I'm leaving my video off as I'm coming to you from my camper in Moab, Utah.
Appreciate the dedication, Mr. Duranolo.
Well, so I do have a couple of things to say about this edit. I want to make sure that commissioners understand that Rule 912A1 does have what staff considers a very strong provision that says immediately upon discovering a spill or release, the operator will control and contain the spill or release to protect and minimize adverse impacts. And the language in the SBP, I'm concerned that that would, I guess, create the implication that if an operator reported a spill or release, they wouldn't have to take action until COGCC made a determination that they were responsible for cleaning it up, controlling, or containing it. And that's not, so I'm worried that that changes the paradigm where operators right now, you know, they see a spill on their site and they take quick action to respond to it. And you know, if there's a shared site, the operator who finds it will control it and contain it, and then they can, you know, work out who ultimately does the long-term cleanup over time. But the initial response action, you know, we want to make sure that that action is taken quickly. So I guess I was more comfortable with that SBP language when it was just talking about those subsurface, you know, finding thermogenic gas, for example, in the subsurface where the source is not readily discernible.
Commissioner Najapa?
Thank you, Mr. Duranlo. I think, you know, I understand what you're saying, and I totally agree. We wouldn't want to add anything that would prevent reporting or action being taken. I guess I was unsure to the extent of what we could put in the SBP for expectations, but at the same time wanting to encourage reporting by anyone who detects you know, the spill. And you know, if we can say, and also, you know, can take those measures. So I think in the language that you're kind of referencing, I know that there's language in the SBP that says, you know, the commission intends for operators to control or contain spills and releases immediately, meaning as soon as they're discovered. I don't know, and I would look again to AAG Davenport or AAG Minor. Can we say regardless of ownership or responsibility or something to that effect? I think we had a little bit of that discussion as well. And so, yeah, so I mean, I think in bringing all this up, my intent is just to be a little clearer that whoever finds it, reports it, tries to do something as best they can, and then understanding that the actual responsibility, the, you know, whatever else that may come after will be addressed, but that we want to have any operator report and perhaps even take some sort of controlling measures. The reason I'm saying all this is there was some testimony, I think, from some of the stakeholders about if it's not ours, you know, we may not need to do anything. And I think we all sort of agreed that no, you should still report even if it's not yours, or you should still do something about it. So I think that's the gist of what I remembered from the discussion that I wanted to see if we could capture, but you know, I don't want to belabor this if we feel that it's addressed enough.
Mr. Duranlo?
Yeah, thank you for that clarification. And I absolutely agree that we do want to, you know, any party who finds a spill or release of E&P waste to report it immediately so that it can be addressed. You know, and again, that's I think there was some testimony of landowners finding E&P waste and reporting it, or calling it in as a complaint. And what staff then found was a reportable release that really should have been reported by an operator. And so I agree that we do want to encourage that reporting, and maybe I would just leave that to AAG Minor to kind of thread that needle, if you will, in the SBP. But I do want to express concern that I don't want to have to get into a responsible party determination every time there's a spill or release on a active oil and gas operation. I think that the operator who is conducting operations on that site should be taking appropriate actions to clean up any found spill or release.
Mr. Chair, if I may.
AAG Minor.
If I may share my screen again. I will take that as a yes. So I did go ahead and move this discussion into the clean version of the SBP and into the correct area. So moving it from the discussion of Rule 912B1 I below to the broader discussion of Rule 912B. And I believe that I have now added language that is directly responsive to both Mr. Dronlo's comment, as well as the additional language about protecting public health, safety, and welfare initially requested by Commissioner Nanjapa. So perhaps we can take a moment for you all to review that language and see if that is indeed correctly tracking it.
Thank you, AAG Minor. Do commissioners have thoughts, questions, comments about the proposed language? Commissioner Gonzalez?
Thank you, Mr. Chair. I'm good with the proposed language, and I'm good with its placement in 912B because 912B directly addresses reporting of spills, and I think that's where, when we crafted this language, we were intending to put it. I think that I also agree with Commissioner Nanjapa's interpretation of our deliberations, that we do believe in the intent of us as a commission requiring the immediate actions for controlling and containing spills as captured in this language. I think it's best in 912B and not 912 in general, or 912A, because 912A2 I think is pretty clear that operators will investigate, clean up, and document impacts resulting from spills and releases as soon as the impacts are discovered. So that's kind of my 2 cents on this. I'm good with it as written and as placed.
Commissioner Nanjapa, can I call on you for alerting us to the point?
Thank you, Mr. Chair, and thank you, Commissioner Gonzalez. No, I completely agree with all of that. I really appreciate AAG Minor putting this out here on the fly so quickly and effectively. So yeah, I'm good with this. Thank you.
Hello, Walter. Any further comments, questions, thoughts, deliberations on the 900 series rules as presented to us, or the SBP? All right. Seeing none, the next step would be for us to take a formal vote on 800, 900, and 1200. Before we do that, I would like to read into the record some comments relevant to 2 issues important to this series. This has to do with pending permits as well as the Our Children's Trust. So if you could bear with. As we did for the 200 to 600 rules, I would like to address 2 points. First, the applicability of the 800, 900, and 1200 series rules to pending permit applications. And second, I would like to address the Our Children's Trust petition as it relates to the 800, 900, and 1200 series rules. The SBP addresses these topics in detail, but I would like to briefly discuss them here on the record for the commission and our stakeholders. Regarding the applicability to pending permits, one purpose of the 800, 900, and 1200 mission change rulemaking is to adopt rules that materially affect and protect public health and safety. The rules adopted in this rulemaking enforce pollution standards, reduce air pollution, prevent and remediate surface and groundwater pollution, and prevent the spread of West Nile virus, amongst other things. The adopted rules also are intended to prevent unsafe situations that could arise and provide better procedures for preventing accidents. These rules prevent induced seismicity, reduce risks associated with venting and flaring, exclude public access to potentially unsafe locations, and require reporting of spills and releases. Compliance with the adopted rules is necessary to ensure that the Commission and all permits it may issue will be in compliance with federal law and regulations. The adopted rules ensure compliance with the Safe Drinking Water Act and EPA Class 2 UIC well regulations, federal waste management rules, federal radioactivity waste laws, the Federal Endangered Species Act, and federal land management and regulation and plans. Finally, compliance with the adopted rules is necessary to ensure the Commission and the permits it may issue will not be in conflict with state law. For example, the adopted rules implement SB 19181 changes to the rule local governments play in regulating siting and surface impacts, implement the transition to a full-time commission, adopt an alternative location analysis, adopt regulations to evaluate and address cumulative impacts, protect and minimize adverse impacts to wildlife resources, and align the Commission's rules with other state regulations. For these reasons, I encourage the Commission to adopt the applicability to pending permit applications section of the SBP as drafted by COGC staff and as presented to us, and find the 800, 900, and 1200 series apply to all permit applications not yet approved or denied as of the effective date, January 15th, 2021. With that recommendation to commissioners, I note we do not need to call this out. We just need to approve the SBP as presented to us. Second, regarding the Our Children's Trust petition, I recommend the Commission adopt the portion of the draft SBP concluding that the rules adopted in this 800, 900, 1200 mission change address the concerns raised by the petition. The 800 series rules regulate underground injection control wells to avoid, minimize, and mitigate adverse impacts to groundwater and surface water. The 900 series rules regulate venting and flaring of natural gas and emissions from pits to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and are specifically intended to reduce emissions of greenhouse gases and other air pollutants from oil and gas operations. The 1200 series rules are intended to protect and minimize adverse impacts to wildlife resources through planning, special protections for sensitive areas, and compensatory mitigation. I, as chair, and the Commission as a whole, thanks the Our Children's Trust petitioners for their sincere, thoughtful, and passionate petition, their pleadings, and their presentations in this rulemaking. The Commission shares your concerns and address them in these rules and the rules in the 200 through 600 mission change rulemaking. We do indeed value your input, your passion, and your commitment to a better future for all of us. We hope you will stay engaged and work with us as we implement these rules to protect public health, safety, welfare, the environment, and wildlife resources. So with that, I want to turn to my AAGs one last time before we potentially contemplate making a vote on the 800, 900, and 1200 series. AAG Minor, AAG Davenport, do you have anything further, or AAG Stafford, do any of you have anything further?
Mr. Chair, I do have one suggestion, which is a change to the draft of the statement of basis and purpose that was sent out on the pending permits topic on the 19th. After further discussion with Ms. Stanzik and the other COGCC staff who are overseeing the pending permits transition, it was recommended that the word amend be changed to replace to reflect that applications will not actually be amended, they will actually be essentially resubmitted. So this is just purely a mechanical reflection of how the actual transition would work.
Thank you, AAG Minor, for that point. I too had a discussion with Ms. Stanzik, and she was hopeful that we would use this word. So I appreciate this final correction and edit, and I think that that is indeed appropriate. Director Murphy, I see you're unmuted.
Thank you, Chair. It's a fairly procedural issue, but Executive Director Gibbs reached out to ask that he be elevated as a panelist, and I thought maybe I would try to ask for that. Well, we had a break in the action.
I know he was hoping to join us ahead of this vote, so let's bring Executive Director and Commissioner Gibbs to the panel. Commissioner Gibbs, welcome. I know that you had other matters this morning, but we're glad to see you with us now by way of informing you as to where we are at with regard to deliberations. You have appeared at the right time. We have had discussion around the substance of the 1200 rules and statement of basis and purpose, as well as the 800 and the 900. And I think we are ready for a final vote on all three rule series, pending me being informed otherwise by my AAGs.
Mr. Chair, I believe that you are ready for a final vote on the 800, 900, and 1200 rule series. I look to AAGs, Minor, and Stafford if we need to be specific about, is there a particular document that needs to be approved, or is it's simply sufficient to, since you're the keepers of those documents, to simply approve them as amended and discussed today? Do you have a specific document reference you think we should use?
AAG Minor.
Thank you, Mr. Chair and Mr. Davenport. I would suggest that the Commission approve the rules as presented today and simply vote to approve the statement of basis and purpose with all of the substantive and non-substantive changes recommended today. And that merely reflects that AAG Stafford and I still need to actually merge the 1200 series SPP into the master 800, 900 document that also includes the introductory section, discussion of pending permits in our children's trust. So we don't have a final document because of that merger still needs to take place. But other than that, I think the substance and all proofreading is all finalized.
Do we need a reference to a docket number?
That may be helpful. So yes, in short.
That would be 200600115.
Okay, I encourage my commissioners for a motion to approve the 800, 900, and 1200 series rules as presented, along with the statement of basis and purpose, with the substantive and non-substantive edits as discussed today, which is case number, docket number 200600115.
So moved.
Second.
We have a motion and a second. Is there discussion? Seeing no final discussion, Hearings Manager Thomas, could we have a roll call?
Certainly. Commissioner Gonzalez,
Aye.
Commissioner McGowan,
Aye.
Commissioner Messner,
Aye.
Commissioner Nanjapa,
Aye.
Chair Robbins.
Aye.
Mr. Chair, you have a 5-0 approval of this docket.
Thank you. Good job. Okay, we're not done. We have the 200 through 600 series before us at this point. So as we did with the other rules, we would do kind of a final check-in on the rules and on the statement of basis and purpose as has been presented to us. I know the commissioners have been on their off time reviewing all of that, which has been a massive amount of time. With that, I would turn to AAG Davenport for perhaps some summation of any final proposed edits, substantive, non-substantive, that commissioners may have caught with regard to the rules and or the SBP.
Thank you, Mr. Chair. Commissioners, I know that with the published draft of the 2 through 600 SBP you have been reviewing, you did make some changes to that. In my view, most of those were non-substantive changes to that. There are a few substantive changes that I would like to share with you. One of them is something you had seen before. Another one is something that a commissioner has raised in the last couple of days. And so we have some language to discuss there. I'm going to share my screen and first show the change that you have all seen before in regard to pending permits. This is something that AAG Minor just discussed in the 8, 9, and 12 SBP. Give me one moment, please.
Very good. Thank you, AAG Davenport.
So can you all see the screen has highlighted language in regard to the pending permits that you just saw from AAG Minor? This is incredibly the first time that I'm actually sharing my screen in this entire rulemaking. So I just want to make sure of that.
Yes, we can see your screen. You're doing a phenomenal job at AAG Davenport.
Thank you. Commissioners, this is the same language in regard to pending permits and the important dates for the pending permits. As you'll see, I've highlighted the language that was added to the SBP. Again, I've also highlighted the fact that the word amend was changed to replace. And at this point, I would just turn it over if commissioners have any questions in regard to this, but this is the same language that you saw again in the 8, 9,
Yeah.
12 SBP.
That looks good to me as one commissioner.
Okay.
Yep, nods all the way around AAG Davenport. Did you have another edit?
I did, and this is something that I'm going to move to a different page of the SBP. Please bear with me while I scroll down. As I do that, I will raise, this is an issue in regard to kind of the definition of mineral ownership in the SBP as a whole. And excuse me, I'm not getting to the right place yet. So this is an issue that was raised by a commissioner, and the SBP refers to mineral owners throughout it. And we wanted to be, this commissioner wanted to be clear about when the SBP refers to mineral owners, that there are a variety of ways that people can have mineral rights. And the rules throughout 2 through 600 are specific in some senses into regard to what kind of mineral rights we're talking about. So this is a general statement. It's proposed as a footnote in the first place that the term mineral owners is used. This footnote actually goes on to the second page. So if you'll permit me, I'm going to use a different document that tracks the same language so you can see it all on one screen at the same time. And this is the same language that would be added in the footnote. It's just in this document so you can see it all at one time. Again, this is essentially language that cautions operators and anyone reading this SBP that they do need to go back to the rule to understand specifically which types of rights in mineral interests are being referenced in this rule. And at this point, I'd turn it over to the commissioner who raised this issue if they'd like to add any additional detail or explanation.
Mr. Chair.
Commissioner Gonzalez.
Yep, and thank you, AAG Davenport, for walking us through that. This is something that I discovered in kind of my second to last read, but didn't really understand the impact of it until I was working this weekend, going back through the SBP. But when I read it, just as someone with land expertise, who has worked through permitting and interpreting these rules, previous rules at least, with regard to which rights are being regulated and are being addressed in the rules, I thought the use of the term mineral owner throughout the SBP captured more than just the ordinary use or the ordinary definition of mineral owner, which to me is someone who actually owns the minerals versus someone who has rights to the minerals. And so I thought it was appropriate that we caution the readers of the SBP to ensure the appropriate rights that are being addressed in the rule through the rules themselves. And I asked AAG Davenport to help me out with this language, to propose to clear that up throughout the SBP. And this is where we're at. So I'm happy to address any questions that may have arisen from this.
Mr. Chair, Commissioner Gonzalez, do you mind if I chime in for one more moment here?
Yeah, please.
Thank you. In my view, this doesn't change any substance of the rules themselves. It does not change substance of the rules themselves. To me, it is a caution to folks who are reading the SBP that they really do need to pay attention to the specific language of the rule to understand which rights in mineral interests are being implicated by that rule.
I'm looking to my other commissioners if there are any thoughts, questions, comments, concerns about this proposed edit. Clarification, I might call it. Okay, AAG Minor, did you have anything more to add?
No, Mr. Chair, I think the only thing I would say is just underscoring that throughout the regulatory text, the style guide that staff conformed to did capitalize defined terms like owner, but those capitalized terms, those defined terms were not capitalized throughout the statement of basis and purpose. That made the document often unreadable, given how many terms are defined. And so I think that this is an important clarification to show the meaning of those defined terms when they're used throughout the SPP, and certainly owner is an important one, and there are many other terms where I think this type of clarification indicating that when a defined term is used in the statement of basis and purpose that is intended to have the meaning ascribed to it in 100 series is beneficial.
AAG Davenport, anything further?
I do not have anything further.
Anything further from commissioners on the 200, 300, 400, 500, and 600 rules or associated SPPs? Commissioner Najapa.
Thank you, Mr. Chair. I had a very minor thing that I raised and wanted to just bring up for the other commissioners. Let me just preface this by saying I'm fine if we just leave it as is. In 604B in the rules themselves, the way in which we have phrased the setback of the 2,000 feet, but with the provisions that we have allowances for between 500 and 2,000. I think that rule language could be plainer. The way it's written now, it says no working pad surface will be located more than 500 and less than 2,000. And I think the way we worded things for the aquatic subsections in 1202C were maybe a little bit clearer in kind of defining the sort of 2,000, is where we're starting from, but we will make exceptions between, I'm mixing these references. In 1200, it was the 500, but we'll make exceptions between 300 and 500. In here, I think it's just a little bit less than clear. Like I said, I'm not going to fall on my sword, so I'll just look to my other commissioners to see if they feel that some additional clarity could be made there. I think the SBP is clear, and I know that is what serves to clarify the intent of the rule, but I always think that the rule language could be as clear as possible as well.
Commissioner Najapa, are you suggesting some proposed edit language here?
Thank you, Mr. Chair. I don't have it fully written out, but I think something along the lines of working pad surfaces may not be located less than 500 feet and must be at least 2,000 feet from one or more residential building units or high occupancy building units, unless one or more of the conditions are satisfied. And perhaps if we need to also say there are 4 locations between 500 and 2,000, something to that effect. So working pad surfaces may not be located less than 500 feet and must be at least 2,000 feet from where the rest of the phrasing starts, one or more residential building units, unless, and then you have the conditions. Yeah.
At this point, I would seek some guidance from our AAGs. I'm for one commissioner, hesitant to change what was a long discussion and arrival at language. I also totally get it, Commissioner Nanjapa, that we want to be clear. So I would ask AAG Davenport or AAG Minor for thoughts about whether the additional clarity is worth the effort of the editing at this point.
Mr. Chair,
AAG Davenport.
thank you. I am just taking a quick look at the SBP in regard to this rule. In my view, the SBP does clarify any issue in regard to this rule language, unless, of course, Commissioner Nanjapa disagrees. So in short, in my view, if anyone does have questions in reading this rule about the foot distances, that the SBP does address Commissioner Nanjapa's concern and would clarify any potential confusion that may arise.
Thank you, AAG Davenport. Commissioner Nanjapa, I see you've unmuted.
Thank you, AAG Davenport, and thank you, Mr. Chair. I don't disagree. I think that the SBP is clear. I was just advocating for as plain as possible as we can be in the rule language as well. But like I said, I will not fall on my sword, so I'll look to other commissioners. If no one else feels it's necessary, then I can abandon this idea.
Well, I, for one, as a commissioner, appreciate the diligence in looking at the language. I am comfortable with the language in the rule as clarified by the SBP language. And having been a local government lawyer that drafted on the fly for 25 years, I was always hesitant to do that. And I would rather, at least as one vote, I would leave it as is and let's implement the rule and start acting under it. Commissioner Gonzalez, I saw your hand as well.
Thank you, Mr. Chair. I support the kind of the language as is. I appreciate us striving to continue to make things clear as best we can. A couple thoughts that I had as these comments were being written was in 604A4, it's explicit that no working pad surface is less than 500 feet. And so I think that makes it clear. And then when I read the rest of it as to the 500, 2,000 feet, no surface will be located there unless, and then it goes to the conditions. As someone who has read these rules, or at least not these rules, but previous versions, through the eyes of an operator, I think it makes perfect sense as is. I don't personally see a need for additional clarity there. And I think the SBP goes into some pretty deep depths about what our deliberations were. So I'm comfortable as is. That's my vote on that.
Commissioner McGowan, Commissioner Messner, or Putnam or Gibbs, does anybody else want to weigh in?
I'll just weigh in, Chairman. So thank you for that. I actually think that Commissioner Nanjapa's language is makes more sense than the language that we have. Although I would also agree with Chairman Robbins that doing edits on the fly, can create some unintended consequences. And I think the existing language, also meets the requirements that we of our deliberations. And so I'm comfortable with the existing language, but in retrospect, I think that Commissioner Nanjapa's language, certainly is good. So.
Commissioner McGowan?
Mr. Chair, I agree with Commissioner Messner.
Okay, so I think we've got kind of this somewhat ambivalent consensus that we'll leave it with the language that we've got now. And thank you, Commissioner Nanjapa, for the note there. If nothing else, this clarifies our intent, this as well as does the SBP on that. I only have one final comment on 2 through 6, which is again getting to the pending permits notion. Contained within the SBP were the final edits relevant to the replacing of permits, and the SBP informs operators that we are asking for notification to commission by March 1, 2021 of those permits that each operator intends on replacing. And then there is a 6-month window until July 15th of 2021 for said replacement to occur. So just noting that that is contained within the record and contained within the SBP so that everybody's crystal clear on how we're moving from previous regulatory protocol to new regulatory protocol. AAG Davenport, did I misstate any of that?
No, that sounds accurate to me.
Any further thoughts, questions, comments, concerns, or anything else on the 200 through 600 mission change rulemaking? AAG Minor, would you care to provide me with a docket number for this rulemaking? Sorry, I really should have had these docket numbers down and I didn't have them.
Mr. Chair, I actually do not know it off the top of my head, so perhaps hearing Officer Thomas could provide it, and I will also perhaps take this moment to just note on the record that I supplied you with the wrong docket number for 8, 9, and 12, which I apologize for. The correct docket number for 8, 9, and 12 is 200-600-155, not 115, and that has also been corrected in the statement of basis and purpose.
Let the record reflect that AAG Minor is human. Thank you so much, AAG Minor, for your work there. The record is corrected. Hearings Officer Thomas, do you happen to have the docket number for 2 through 6?
Yes, that docket number is 2003-00071.
Great. At this point, I think we're looking for a motion to approve the 200, 300, 400, 500, 600 rules as presented, as well as the associated statement of basis and purpose for docket number 2003-00071.
So moved.
Second.
We have a motion and a second. Is there further discussion? Seeing none, could we have a roll call?
Commissioner Gonzalez,
Aye.
Commissioner McGowan,
Aye.
Commissioner Messner,
Aye.
Commissioner Nanjapa,
Aye.
Chair Robbins.
Aye.
Mr. Chair, the motion passes by a vote of 5-0.
Thank you, Hearings Manager Thomas. Thank you, Commissioners. with that, I think we've concluded our mission change rulemaking. I've got a few comments, and then I would encourage others if there are additional comments. I want to thank everyone for the support and the hard work. We are happy and I think a bit relieved to have finalized this historic rulemaking to help COGCC meet the spirit and mandates of SB 19-181. To my fellow commissioners, to Director Murphy, to staff, to Deputy Director Cuthbertson and managers Mimi Larson, Greg Duranlo, Mike Leonard, Jane Stanzik, Dave Andrews, and to all the COGCC employees who worked tirelessly on this rulemaking. Thank you. We simply would not have achieved this success without each of you. And to our impeccable, indefatigable Assistant Attorney Generals, Kyle Davenport, Joel Miner, Caitlin Stafford, thank you for your drafting, your words of advice, and keeping us within our legal framework. 5 months ago, commissioners, you embarked on a challenge to the first ever full-time professional commission. You have demonstrated courage, determination, professionalism, thoughtfulness, and dedication to take on recasting an agency's regulatory approach on day one and assume responsibility for setting the course of this action. And to Commissioners Gibbs and Putnam, thank you for your incredible time commitment, expertise, and contributions to provide your invaluable perspective to get this done right. I can only imagine the doubling down it took for each of your participation with us, given that you both have day jobs. Finally, to our stakeholders, to our regulated community, to the local governments, to the conservation community, to the HOAs and community groups, and to the individuals across the state who took time to participate, a heartfelt thank you. As you can see from the final drafts, your participation in this process was critical to the balanced, thoughtful rules we have adopted today. And we did all of this in a global pandemic. I think one unintended benefit to that is that it may have allowed more participation and was less disruptive to the public and our partners to participate virtually. To Ms. Larson and to Mr. Thomas and to Angelica, thank you all for your hearty work on Zoom. It is truly appreciated. Last year at this time, we would never have imagined conducting hours of public comment, deliberations, and presentations with a cup of coffee from our home. So to that, I want to thank everyone's family and their friends and their loved ones for supporting all of our stakeholders and our commissioners. It really is heartfelt. Last year, when Governor Polis signed 19-181 into law, many of us were very much involved with that legislative effort. On the other hand, we have a lot of new participants and stakeholders who have helped implement the legislation's tenets, and many have become involved for the first time. For that too, we are sincerely appreciative. This shows how well we have done by expanding the standing of COGCC and bringing new perspectives and voices that have allowed us to find the best reasonable solutions for Colorado oil and gas operations. To that, I and my commissioners thank the 90+ rulemaking parties, the hundreds of elected officials, homeowners, environmentalists, and industry representatives for their collaboration and partnership to deliver these rules that provide a path forward for oil and gas production in a manner that protects Colorado and that provides all of us a voice and a seat at the table. I too want to acknowledge that there are a lot of folks out there who are not happy with every aspect of the rules adopted. And in that disappointment, they want to throw barbs. They want to drive wedges. They want to claim that this rulemaking will surely shutter the industry or claim that this rulemaking failed to implement 181. I completely disagree. To start, I ask folks to get educated as to what has been accomplished. Before editorials are published, folks should at least read the rules and familiarize themselves by talking to all stakeholders to truly gain understanding of the pathways for oil and gas. In fact, I have had discussions with our regulated community as well as others, and largely I have received positive support for where we have landed. There is a recognition and appreciation for the fact that the new rules are more robust and tougher and more comprehensive. But to a T, people seem to understand that this was to be expected when moving the landscape from fostering to regulating in a protective manner. And I've heard thanks for the rules recognition that the additional protections should not at all times be hard or blunt. And we have developed off-ramps, alternative methods to achieve compliance. There are alternative location assessments to ground truth, and there are waivers and exceptions and variances. And I, as one commissioner, reiterate, we did not build this rulemaking with its nuanced methods to achieve compliance to not use them. Off-ramps should be considered and used. Smart landscape level planning should be considered and used. I am truly confident that as we move into the day-to-day permitting in 2021, that we will prove that we have accomplished the legislators' goals and the governor's goals of regulating and allowing for oil and gas development to occur in our great state in a manner that is protective of people, our environment, and our wildlife. This chapter of the rulemaking for mission change rules closes with a unanimous vote, and in large part, strong consensus from all sides. We know we have much work to do to support the implementation of these new rules, to take on the final 3 SB rulemakings in the next year, and in our daily duties as commissioners. We should have every reason to expect the best and success based upon our work together and our accomplishments over the past months. And before I finish, I want to make a special shout out to Director Murphy. Your ability to focus, motivate, and lead an exceptionally talented team, along with your wit and wisdom and compassion, has been the cornerstone of our success. So thank you, everyone. And in the spirit of the upcoming Thanksgiving, all of our best to all of you for a safe, healthy, and happy holiday. So thanks for all we've done. Whew. Other commissioners with thoughts? Commissioner Gonzalez?
Tough to follow that one, Chair Robbins, but I've got a very short comment to make. So I'm just going to read that off, and I want to echo everything that I heard from you and really appreciate the words to kick us off. These rules, they define a new era of the Colorado Oil and Gas Conservation Commission. And with this change comes opportunity, but also uncertainty. We've tried our best to create rules that are necessary and reasonable for the protection of our state's people and resources. And we've tried to do so in a way that is workable for the Colorado oil and gas industry. These rules do not effectively ban oil and gas operations, nor are they a codification of Proposition 112. They are rules that fulfill the statutory directives of this commission. They are fair, they are reasonable. Accordingly, I believe the rule framework we've created will allow for transparent, protective, and responsible oil and gas development by the proud oil and gas workers and operators in our great state. Thank you to all of the stakeholders who engaged in this process and helped us get where we are today. And finally, thank you to staff, to our AAGs, and to my fellow commissioners for their thoughtful consideration throughout this process.
Thank you, Commissioner Gonzalez. Commissioner McGowan, I think I saw your hand.
Thank you, Mr. Chair. And I echo what everyone has said today. And I do want to add that I'm most appreciative of staff and the parties and stakeholders for the space and grace they've given to those of us who are newer to some of these issues and answered questions with patience and perseverance. I was incredibly grateful for the really comprehensive, thoughtful testimony and evidence and studies, et cetera, that people put forth, and the willingness to meet also one-on-one to further dig into what folks wanted represented, what they were worried about, how they did their daily operations. Thank you to staff who spent a lot of time with the commissioners to explain why the rules were written the way that they were and drafted, helping come up with solutions, the behind the scenes working from parties. When the commission said, could you all see if you can come to some sort of resolution? The staff and the parties, I feel, were really earnest in their efforts to make that happen. And I guess the last thing I'd like to say is we know that this is a work in progress, and I'm looking forward to implementing the rules, but also understanding that some of them maybe might need to be tweaked. Maybe this just wasn't the perfect first time, but we're all here full time and we're here to listen to folks and we're here to discover what is successful and what maybe we can improve upon. And I'm really looking forward to working with everybody. And thank you to my fellow commissioners. Really a thoughtful group of folks. And I hope that everyone who's been listening to us understands that this is really hard to do via Zoom. And it's hard sometimes not to know what another commissioner is thinking exactly, except in a public meeting via Zoom, and try to get to a place where we all of us come from a different perspective. And I think that I feel like we did a really good job working together and coming up with some good rules. And I'm just appreciative to everybody who participated in the process. I thought it was very professional. I thought people had a lot of patience and a lot of perseverance, and I'm really appreciative of that grace and space that everybody gave.
Thank you, Commissioner McGowan. Commissioner Messner?
Thank you, Mr. Chair. And thank you for all the comments up to this point. I mean, certainly heartfelt. I did write some comments down myself, and so I'll read those. But I think the gist of my comments is thank you. Thank you to the folks participating on this call. Thank you to the folks across Colorado who have spent hundreds of hours with us through the scope of this rulemaking, sharing their experiences, their expertise, their solutions and suggestions towards making this set of rules the best that we can make them. I, as an individual commissioner, could not be more impressed by all of the parties that have been involved in this process. I have learned from each of you, and your passion and dedication was clear every day. You pushed when you needed to push, and you bent when you felt like you could bend. You understood the challenges and implications to what we were trying to accomplish. Rulemakings are hard, and this one certainly harder than most. To use a cooking metaphor, having hundreds of chefs trying to cook a stew is hard enough. But having hundreds of chefs also trying to write the recipe while you are cooking seems impossible. But that's what we did, and that's what you did. And it could not have been done without trust, without communication, collaboration, dedication, professionalism, and thoughtfulness. So again, thank you. To the staff, I just don't think the words thank you are enough. Your unbiased efforts towards developing these rules, the thousands and thousands of hours working with stakeholders, working through the weekends, the evenings, losing evenings with family time, the sleepless nights, the early mornings. You have put your blood, sweat, and tears into this effort, as you do with everything. I want you to know that I have not been a part of a more dedicated, honest, and professional group of people in my career. So thank you. To my fellow commissioners, again, throwing us together in a global pandemic to undertake, an incredibly challenging situation. I couldn't be more appreciative of the intelligent, dedicated, thorough and courageous group that you are. So thank you. And so here we are, having completed this series of rulemaking, making a Herculean shift from fostering oil and gas development to unbiasedly regulating oil and gas development in a way that protects public health, safety, welfare, the environment, and wildlife resources. I said it when we started this rulemaking, and I'll say it again. I do believe it is possible to regulate oil and gas in this state in a way that is protective of public health, safety, welfare, the environment, and wildlife resources, while still maintaining a successful oil and gas industry, which is an important economic and workforce driver for Colorado. I think what we have created here is a framework for that to happen, and I look forward to continue this path as we implement the rules we have developed into the future. So thank you all, and yeah.
Thank you, Commissioner Messner. Commissioner McGowan? I'm sorry, Commissioner Najapa?
Thank you, Mr. Chair. Boy, it's really tough to follow all of those wonderful comments. And so I'll generally just say, hear, hear. I had many of the same comments prepared myself. But I will specifically say that I also appreciate the depth and breadth of the comments and the information that was presented by the public, the stakeholders, and especially the parties, and just completely concur with the comments that Commissioner McGowan said regarding the space and grace for those of us who are very new to this industry and to the operations therein and these rules, and appreciate the patience that everybody had in the questions that we brought forward, and in helping us understand. I've learned a ton from all of you as well. And I also want to give a specific shout out to the staff for their immense efforts. I'm just continually impressed with the depth and breadth of their knowledge, their understanding, and their ability to explain and connect all these different dots. And just want to again express appreciation for the thoughtful, careful, and balanced approaches that they drafted that allowed us to more easily deliberate and to consider appropriate rules that meet our mission. And with that, a special thanks to our AAGs, Davenport, Minor, and Stafford for all of their excellent work, and then also especially to Director Murphy. I think the ability to bring all of this information together on such a short time frame, and sometimes within hours notice, is just astounding. And I appreciate that you always had a smile on your face and could make a few cracks here and there. Really appreciated that in these long hearings. And then last but not least, just a thank you to all my fellow commissioners. I think it's been an excellent experience, and I'm sorry that we can't be all in the same room and go grab lunch after this, but it has been a wonderful experience to work with all of you. I think you all have brought so much to the discussions, and I'm really grateful to be a part of all of this with all of you. So thank you so much.
Thank you, Commissioner Najapa. Commissioner Putnam, and then Commissioner Gibbs.
Thank you, Chair Robbins, and I won't repeat all of the well-deserved thanks to all of you as commissioners, to the parties, stakeholders, general public, Director Murphy, and staff. Want to highlight a couple of thanks just to make sure we don't lose the great input that we had from Parks and Wildlife staff, CDPHE staff from the Air Pollution Control Division, Water Quality Control Division, Hazardous Materials Waste Management Division, who have been, critical in putting a lot of these pieces together. Certainly the Attorney General's office. I'd like to give a special thanks to Sean Hackett, our energy liaison at CDPHE, who's worked as a go-between between our department and DNR, and wouldn't have gotten here otherwise. I think the main thing I want to focus on, though, is that, and this picks up on Commissioner McGowan's comments, great regulations are only as good as their implementation. And as hard as this great work has been, now the real hard work starts, which is actually making this work in the real world, to actually give meaning to, I think, the great rules that we set up on environmental justice. We've got to make those real. We've got to make those count in the real world. And it will take all of our efforts on the commission, on staff, with stakeholders, the public, to really make those rules stick. And we have a number of, certainly it's been referenced, other rulemakings that this commission needs to do, financial assurances and so forth. But AQCC has important rulemakings to come. The Board of Health just passed important new T-norm regulations they're going to have to work, and we're going to have to integrate all of those in. And so my fervent hope is that everybody who has been part of this process stays involved in these processes, because we're going to need everybody's help to actually realize the potential for this really great and historic set of rules. So while we celebrate the hard work and great accomplishments today, hoping that we'll all dust ourselves off first thing tomorrow morning and really lean into implementation. So thank you all, and look forward to being part of that.
Thank you, Commissioner Putnam, and thank you for the shout outs to our sister agencies and to the employees of said agencies. Couldn't have been done without them as well. And so we really appreciate that perspective, and those thanks are genuine. Commissioner Gibbs.
Thank you, Mr. Chairman, and ditto all around. I mean, I love hearing all the comments, and I can't agree more. And it's just amazing to see, where we're at now, after Senate Bill 181 passed. Shout out to some of the, previous commissioners, kicking off the administrative series, the 500 series, the flow lines, wellborn integrity, to the current commissioners. I mean, the series, 200 through 1200, the amount of work you all put in. It's funny, like, it seems like yesterday that I was with the governor interviewing you all, and we were just so impressed, that, you all bring such a unique perspective. You're all extremely intelligent, but it was kind of like, okay, how are they all going to mesh together? How are they all going to be different in their own ideas? And how are they going to just, work to implement this? And it's just amazing to see how you all, operated. And, shout out to you all for putting, all of your time to make this happen. Also want to give a shout out to Julie Murphy. Julie, seems like yesterday you were my assistant director for energy and minerals, that you've kind of gone back and forth from OGCC a few times, but you have been such a great trooper to really fill in where you're most needed, at times. So I really, being the head of the DNR, I really appreciate that. And you came back at a time when we needed you, and really appreciate that. And being a former legislator, it was great hearing from legislators during this process to hear their legislative intent. I really appreciate their leadership. It's nothing like having the Speaker and the Senate Majority Leader to be lead sponsors of Senate Bill 181, and then have the governor's full support behind having the trust, really, that this new commission would have to really get this right in Colorado, to look for that balance of the importance of oil and gas and the balance of protecting public health, safety, welfare, the environment, and wildlife resources is extremely important. And then Director Robbins / Chairman / friend Robbins, you've also really stepped up big and really filled in where the state has needed you most. You stepped in to help out, to be the director of OGCC. The governor saw his leadership and vision in you to be the chairman of this. I would say it's probably not easy going from, overseeing a department to then, being more in a policy realm and making sure that all voices are heard during this process. And, as a former chairman of this myself, I was really impressed with you, Mr. Chairman, of how you've handled this whole COVID-19, but really make sure voices are heard. We all know we're not going to agree with everything that people say, but I really felt, whether you're oil and gas or environmental community or local governments or whoever it may be, I really feel like you set forth an environment that was safe for people to share their thoughts and concerns. And I think that's really, really important. And that will help us lead to, future rulemakings and success for OGCC. So thank you all around. Really appreciate all of your leadership.
Thank you, Commissioner Gibbs. DNR Director Gibbs, we really appreciate those thoughts and comments. I think I'd like to close out by calling on Director Murphy.
Thank you, Chair. And I will do my best to hold it together between being proud of today and also somewhat exhausted. My emotions are riding higher than normal, perhaps. But first, a thank you to everyone for the support and hard work. Today, the chapter of the mission change rulemaking hearing has come to one end. With the vote today, we've closed the book on setting policy for the moment, and we do have a lot to do before us with implementation. If we remember back to my first presentation in August, which might have been 300 years ago, and remember the Decalibron slide that I started with. Today we take a turn to return to the trailhead and onto the work of implementation. As I said then, I still believe now, we return different, stronger, better, with all of the work and input we've received. Our success today would not be possible without the COGCC staff and our stakeholders. At this point, stakeholders isn't even the right word. It's our partners who toiled along with us, making the same sacrifice in the midst of having lives and other commitments. Oh, and just during a pandemic, no big deal, right? 2020, you've been one for the record books in so many ways, but today it's a really positive one for me. I am so incredibly proud of the staff at COGCC who supported the hearings through months of preparation, presentations, and 181 hours of Zoom deliberations. Yes, that's an incredibly coincidental amount at best, but I did sum it up, and it was 181 hours at the conclusion of last week, which blew my mind. So for anyone else who has Zoom fatigue, we sure know why. And many of us have had our pets and children make appearances, including my kiddo and dogs, and even today he got to use me as a climbing gym. We also know that the hearings are only one facet of the work that has poured into this process. Again, I'm so thankful and proud of our staff, including the many folks who appeared on the Zoom rulemakings, from managers to our assistant attorney generals, and to our partners at CPW, Division of Water Resources, also within DNR, and within CDPHE. There are so many individuals who contributed so much. And thank you to the families and the loved ones who have supported all of us who are doing the day-to-day work on this rulemaking through the process. Our support of the rulemakings began with the months of work that came before to lay the groundwork, and all this has occurred while we are all doing our day jobs or supporting others so they could shift their focus to answer the calls for commissioner questions and rulemaking prep. Again, our success today was dependent on staff's knowledge, experience, and ability to collaborate, and an ability to listen to our partners' viewpoints and help craft reasonable and productive solutions that will protect Colorado. Next year, as we begin implementing the rules adopted today, we also begin a transition in our organization. I look forward to the work we will do together and the collaboration across state government as referenced by Commissioner Putnam. This was no small feat. Our journey continues now with implementing the rules, and then we have 3 remaining Senate Bill 19-181 topics to conduct next year. We look forward to completing our obligations and working again with you commissioners. I want to recognize the incredible amount of work you have poured into this. Thank you for your support and guidance and leadership and grace. To Commissioner McGowan's point, each of the 5 of you learned how to work with each other through a new set of agency rules, all during a public meeting and wrestling with some of the most complicated, nuanced issues that I've ever come to know. And that was your day one charge, right? I can't imagine a more challenging way to start a job, but I'm continue to be impressed by the camaraderie, the listening, and also the willingness to disagree and work through issues that you have demonstrated. To Colorado, thank you. So many of us poured ourselves into this process, and through your work, we have rules that implement 181 with the same nuance and complexity appropriate for the Colorado that we know, love, and want to preserve for our children's children. Thank you for the collaboration and grace through this process. We listened to each other and echoed the Colorado way of disagreeing without being disagreeable. Lastly, I want to express my thanks to Mimi Larson, our hearings manager, for her undaunted dedication and commitment to conduct and complete these rulemakings. Mimi is not here with us today, but she will soon begin maternity leave, and we couldn't do this without her. Ms. Larson, we are thrilled for you as you begin your next chapter and wish you all the best. Also, the last 3 months might be the best preparation for parenting, unrelenting, exhausting, and in service to something greater than ourselves. As Chair Robbins noted, and in the spirit of Thanksgiving, my gratitude to each of you for your consummate professionalism, leadership, and kindness as we implement these historic changes with COGCC. And with that, I've started crying, so I should wrap it up.
Thank you, Director Murphy. Thank you all. It's genuinely moving to see such grace and consensus around really difficult topics. Folks, I believe we're done. I think we're looking for a motion to adjourn.
I'm going to miss you all, but so moved.
I will second that and wish everyone a happy Thanksgiving.
We have a motion and a second. All those in favor signify by saying aye.
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 Happy Thanksgiving, everybody.
Happy Thanksgiving.
Happy Thanksgiving.